You and your partner contribute towards buying a land. You bring 2 million naira, he contributes 3 million. You buy the land, build on the house, raise your kids. Let's talk about joint ownership of property in Nigeria. Joint ownership is a situation whereby two or more persons share legal rights over the same property. I know it sounds pretty straightforward, but it is not, because the type of joint ownership you have is what determines everything. There are two main types of joint ownership. You have the joint tenancy and tenancy in common. In a joint tenancy, both owners to the property own it in equal shares or equal rights. Nobody has a specific portion. And another thing you need to note is that in a joint tenancy, one person cannot sell his or her share in that property without the consent of the other person. This is an important part when it comes to joint tenancy. When a partner or co-owner of the joint property dies, the property or his share in that property does not go to his estate or his children. It automatically goes to the surviving owner. This is called the right of survivorship. Now, for the second type of joint ownership, which is a tenancy in common, here each owner of the property holds a distinct or different interest or share in the property. It could be equal or unequal. It all depends on how much they contributed or how much they've agreed to contribute towards acquiring the property. Now, unlike joint tenancy, in a tenancy in common, if a partner or co-owner to the property dies, his interest or share in that property goes to his estate or his children. If the deceased had a will, his interest would also go to his beneficiaries who are named in the will. Now, there's another mistake a lot of couples make. When you're buying properties together as a couple or jointly, the deed must and should reflect your individual names. There is nothing like Mr. and Mrs. John Odo. No, it should reflect as Mr. John Odo and Mrs. Annabel Odo. Mr. and Mrs. John Odo is not recognized under the law. They cannot sue. They cannot also be sued. Now, what if you contributed to acquiring the property, but your name is not on the deed? What happens? You can still establish a claim, but the thing is, you have to prove it. You have to present receipts, bank transfer records, evidence of witnesses. In fact, every evidence that shows joint contribution, you have to present it. What if the co-owners to a property disagree? What happens? If joint owners to a property cannot decide on what to do with it, whether to sell it, how to manage it, share the income, or whatever it is, then a co-owner to that property can apply to the courts that the property should be partitioned. So how can you actually protect yourself in a joint ownership of property? First, you have to decide from the beginning whether you want a tenancy in common or a joint tenancy, and make sure that the deed or the document reflects this. Secondly, as you're making financial contributions, make sure you document everything. Thirdly, if you decide to choose a tenancy in common, make sure that you draw up a will that specifically shares or addresses your property to the beneficiary. If you and the co-owner to the joint property decide to go separate ways, then make sure to execute a deed of partition. This deed of partition formally converts joint ownership of property to individual ownership.